Hey, everybody. Welcome back. Welcome back to the Law of Self-Defense show. Come on in, folks. We have hopefully what'll be some fun cross-exam for all of you today. Cross-examination of the psychiatrist hired by the defense as an expert witness for Michael Barisone. Yes, we're back on the Michael Barisone attempted murder trial once again today. Yesterday, we covered the direct questioning of this psychiatrist. Dr. Stephen Simring, retained by the defense. There was, frankly, not all that much interesting in his testimony, except for the last 30 seconds, which we'll replay for all of you at the start of today's show. Come on in. I'll give a quick recap of the facts and law, relevant law, and proceedings to date of the Michael Barisone trial as people filter in. Most of you have heard this recap before, but for those of you who did not hear it before, in any case, we need time for people to find their seats and so forth when we start the show. So this is the trial of Michael Barisone. Michael Barisone, a horse trainer in New Jersey, had a horse farm in New Jersey, trained horses and people in the sport, the art of dressage, whatever you want to call it, a kind of a funny kind of horse riding. Apparently an Olympic sport. Michael Barisone himself was an Olympian level dressager, if that's a word. In the past, now later in his career, he's a trainer of others. And he had invited to live on his horse farm and be trained by him one Lauren Kanarak, a woman in her 40s at the time. She came to live on his farm, became a tenant there. She brought with her her boyfriend, Robert Goodwin, and a horse or two. And the idea was she would be trained by this former Olympian, Michael Barisone, in the art or sport of dressage. Unfortunately, the relationship between Michael Barisone on the one hand and Lauren Kanarak and Robert Goodwin, her boyfriend, on the other, became extremely toxic, unbelievably toxic. By all appearances, Lauren Kanarak and Robert Goodwin are horrible people. They appear to have intentionally sought out to destroy, emotionally, psychologically, reputationally, professionally, destroy Michael Barisone. They put all kinds of vile things on social media, and they're not shy about admitting it. They both testified during the state's case in chief in this trial, and they were, by all appearances, quite open. Social media is for shit posting, and we spent our time on social media shit posting Michael Barisone, saying the most horrible things about him we possibly could. And Michael Barisone himself appears to have been emotionally and psychologically fragile from the start. Apparently, he has a history of being abused all the way from childhood, presented to the outside world as a confident dude, but in fact was extremely fragile. And by all appearances, he was broken by Lauren Kanarak and Robert Goodwin. He tried to get them to leave his property many times, asked them, they refused to leave. He got his lawyer to gin up what turned out to be really a fake eviction notice. It was never filed in court. It was, his lawyer says, Michael Barisone's lawyer who prepared the eviction notice, says he never filed it on purpose. They were really just trying to scare Lauren Kanarak and Robert Goodwin into leaving the property. But by then, it was like a day before the culminating event here. And the culminating event occurred when Michael Barisone approached Robert Goodwin, said, hey, this is getting really heated. We don't need a war here. Can't we settle this? And Robert Goodwin told them, it's too late for that. The lawyers are involved. Let's let the lawyers settle it. Robert Goodwin was walking away from Michael Barisone when Lauren Kanarak walked past the departing Robert Goodwin, approaching Michael Barisone, and said more vile things to him, essentially saying she was reporting to state Child Protective Services that Michael Barisone was molesting the child of Michael's girlfriend. There appears to be no evidence of that happening at all. It appears to be a fraudulent claim, but sufficiently horrific to Michael Barisone that his mind broke in that moment, according to him. He actually has no recollection of the events that follow that accusation by Lauren Kanarak, no recollection until he later regains recollection in the ambulance on the way to the hospital. But what happened, according to the only other two eyewitnesses, who were Lauren Kanarak and Robert Goodwin, obviously anti-ethical to Michael Barisone, but they say that Michael Barisone pulled out a pistol, shot Lauren Kanarak twice in the chest, and she was, in fact, shot twice in the chest, and shot at Robert Goodwin, but missed, blew out a window in the home that Kanarak and Goodwin were living in on Michael Barisone's property, upon which Robert Goodwin pummeled Michael Barisone gave him a pretty good beat down, pretty severely beat him up. And that's the sequence of events claimed by Lauren Kennerak and Robert Goodwin. So that they were shot at by Michael Barisone without justification. They did beat him. Even Lauren Kennerak apparently got a knock-in with her cell phone in her hand. Their dog bit Michael Barisone, but they say all that happened after he shot them or at them, and they were doing all that in self-defense, which would be self-defense. They were beating him to avoid getting shot by him again. Reasonable enough. Supporters of Michael Barisone suggest that, in fact, the sequence of events was the reverse, that they attacked him first and then he shot them in self-defense. But there's actually no evidence of that at all, largely because Michael Barisone has no recollection of events, he says. So the only other witnesses are Kennerak and Goodwin, and they're not saying that they attacked first. So there's literally no evidence that they attacked first, which is problematic for the defense. And because he shot Lauren Kennerak twice, she obviously survived those gunshot wounds. She testified at trial. She's still alive today. And shot at Robert Goodwin. The state has charged Michael Barisone with two counts of attempted murder, which is what he's on trial for now. And also, of course, he used a gun, and this was New Jersey. So he's facing a gun charge as well, because he was not legally permitted under New Jersey law to be in possession of that gun. It was, quote unquote, loaned to him by a friend shortly before this event. What we do know, what Michael Barisone himself has conceded to, is he went to that final confrontation with a gun, because the accusation by Lauren Kennerak about him molesting his girlfriend's child was the final straw, as he communicated to his own psychiatrist, whose cross-examination we'll hear today, whose direct testimony we heard yesterday. So what are the possible legal defenses here? Well, there's two theoretical perfect defenses. A perfect legal defense is one that can lead to an acquittal, zero criminal liability. One is self-defense, but self-defense is problematic here because, well, where would the grounds of self-defense come from? Remember, any claim of self-defense has to have the 5 elements of self-defense, unless an element is waived for some reason. None would be waived here under New Jersey law. So all 5 elements are required. Those elements are innocence, imminence, proportionality, avoidance, and reasonableness. For those who are not familiar with those elements, I would urge you to at least download our free infographic that we make available at lawofselfdefense.com/elements. If you don't understand these 5 elements, you can't possibly understand use of force law, meaning defense of self, defense of others, defense of property, because these are the building blocks for any claim of self-defense, no matter what state you're in. Now, these are the maximum number of building blocks. Not all states apply all 5, but the most that would be applied are 5. New Jersey is one of the states that would apply all 5. So all 5 of these elements, innocence, imminence, proportionality, avoidance, and reasonableness, apply in the case of Michael Barisone if he wants to justify his shooting of Lauren Kennerak and the shooting of Robert Goodwin as self-defense. In other words, there has to be some evidence that he was defending himself against an unlawful use of deadly force, an unlawful imminent use of deadly force by Lauren Kennerak and Robert Goodwin, and that force was otherwise unavoidable by safe retreat. Those are the conditions that would be required under New Jersey law. Now, there doesn't need to be a lot of evidence of that per se. Once Michael Barisone, the defendant, has raised more than 0 evidence, prima facie case of self-defense, then the burden's on the state prosecution to disprove self-defense beyond a reasonable doubt. Unfortunately, in this case, there's so little evidence in support of these 5 elements that it's quite possible that the state won't have to disprove self-defense, that self-defense will not, in fact, be permitted as a legal defense, that the jury will never be instructed on self-defense. And where would the evidence for these 5 elements come from? Well, they're not going to come from Lauren Kennerak and Robert Goodwin. They've already testified. They have not provided evidence in support of these 5 elements. So it's going to have to come from, it would have to come normally from Michael Barisone himself, except he says he has no recollection of the events. And there were no other eyewitnesses. So it's quite possible that self-defense simply is not a viable legal defense in this case at all. I know lots of people want to believe that Barisone is the innocent victim here and was justified in shooting Kennerak and Goodwin because Kennerak and Goodwin appear to be horrible, horrible people. But you're not allowed to shoot people just because they're horrible to you, just because they're mean, just because they're bullies. And if you want to claim self-defense, in court, you need evidence. I mean, just speculating self-defense is not a legal defense. Speculation is not a legal defense in court, folks. So, turn down the emotions and think with the rational side of your brain and show me the evidence, the actual evidence, not speculation, of self-defense, because I don't see it. So that's one perfect defense. And by perfect defense, we mean if the jury bought the argument of self-defense, that would be an acquittal, no criminal liability. Michael Barisone would go free. But I don't see the elements of self-defense being supported by the evidence here in this case. And I don't see where that evidence would come from at this point, frankly. The other perfect defense is the insanity defense. Not guilty by reason of insanity. That would also be an acquittal in terms of criminal liability. It doesn't mean Barisone would go free. It means he would be institutionalized for some indeterminate period of time until his doctors decided it was safe to release him back into society. But there would be no criminal liability. He wouldn't be in prison. He'd be in a psychiatric institute of some kind, whatever they call those things today. Don't want to be politically incorrect. The difficulty with the insanity defense, it's a very high threshold. In essence, you have to have not known that you were shooting a human being. You have to have thought you were shooting a Martian or a werewolf or a robot. That's the standard. And I don't see that standard being met here, although we have a very interesting facet of this case, and that is that ties in with one of the imperfect, not perfect legal defenses here. So I don't see the traditional threshold for insanity defense, the second perfect defense in this case, theoretically, being met. But there is an imperfect defense here. It's called imperfect self-defense. And that applies where the only defect in your claim of self-defense is that while you did have a subjective, genuine, good faith belief in the need to act in self-defense, that belief was objectively unreasonable. It was irrational. A hypothetical, reasonable, and prudent person would not have shared that belief. Now, that doesn't get you to an acquittal. An imperfect defense does not get you to an acquittal, but it would mitigate murder to manslaughter, or in this case, attempted murder to attempted manslaughter. And, usually the crime, an attempt crime, is punished to the same degree as the crime. You don't get a break for having failed in your attempt. So he'd be looking at a manslaughter type sentence instead of a murder type sentence, which sounds, manslaughter sentence is no party. But murder is often life in prison without possibility of early release. Manslaughter might be 10 to 20 years and get out on parole in a third of that time, still have some life to live outside of prison. So a manslaughter conviction sucks unless the alternative is a murder conviction. And then in that case, a manslaughter conviction is a win. So they may be trying for imperfect self-defense here. Another mitigation defense would be diminished capacity, that the torture, the mental, emotional, psychological torture to which Michael Barisone was subject by Lauren Kanarek and Robert Goodwin, which seems really incontestable, was of such a degree that it broke him mentally. And he mentally was not able to form the state of mind necessary for murder, that instead the most he could be convicted of, given his diminished capacity, would be manslaughter. Again, it's mitigating murder to manslaughter, attempted murder to attempted manslaughter, the same outcome as imperfect self-defense. And then there's just a wishful kind of defense, and that is if you can paint these, the victims of the use of force here, Lauren Kanarek and Robert Goodwin, as sufficiently vile that the jury will have so much animosity towards them and so much sympathy for your client, Michael Barisone, that they'll either acquit him or, just out of the goodness of their heart, convict him only of some lesser included offense. That's not really a legal defense. That's just an emotional argument to the jury. Now, what's interesting here is we just had the defense psychiatrist, the expert witness, testify. They did direct and cross yesterday. Yesterday, we covered the direct, and frankly, it got late in the day. So I didn't do the cross examination that occurred yesterday. I'm going to cover that cross that happened yesterday. We'll cover it in today's live show. So we'll be watching yesterday's cross in today's live show today. For those watching on YouTube, as I'm recording this, is April 7th, 2022. Yesterday was April 6th, 2022. That April 6th is when the cross examination actually occurred, just to be clear. I'm speaking live. The cross we'll be watching took place yesterday. And the direct examination by psychiatrist Stephen Simring was not particularly interesting, except for the last few seconds. In the last few seconds, and I'll play this for all of you again, the defense counsel, Edward Belinkus, not a world-class performer so far in this trial, in my view, but defense counsel asked the psychiatrist, did Michael Barisone know right from wrong? I mean, that's really the criteria for the insanity defense. Did he think he was, I would phrase it as, did he think he was shooting a human, or did he think he was shooting a robot or a Martian or a werewolf? That's the traditional threshold for insanity defense. You didn't know right from wrong. You didn't know you were shooting a human being. And the psychiatrist says, no, he did not know right from wrong. And then the psychiatrist continues and says, he thought he was shooting in self-defense. Well, this is an interesting blurriness now between what would normally be imperfect self-defense. You had a genuine subjective belief that you were acting in lawful self-defense, but that belief was objectively unreasonable. That's an imperfect defense that would mitigate attempted murder to attempted manslaughter. What the psychiatrist appears to be trying to imply is that that should qualify, that should be sufficient, that he thought he was acting in lawful self-defense, that should be sufficient to qualify as an insanity defense, which is not a mitigation defense, it's a perfect defense. It would be an acquittal on the criminal charges. So he didn't know right from wrong, not in the sense that he thought he was shooting a werewolf, but he didn't know right from wrong in the sense that he thought he was committing a lawful act in shooting Canarak and Goodwin. Even though that thought was irrational, he believed it. And in that sense, he didn't know right from wrong. In that sense, he was, the psychiatrist is suggesting, legally insane. Now, I've seen a lot of claims of imperfect self-defense where a person believed they were acting in lawful self-defense, but the jury concluded that was an irrational, unreasonable, objectively unreasonable belief. They were convicted. Essentially, they were mitigated under imperfect self-defense from murder to manslaughter. I've never seen an imperfect self-defense argument be parlayed into the perfect defense of insanity defense. Those are traditionally two completely different things. What appears to be happening here is that the defense is trying to blur what looks like it could be imperfect self-defense into insanity. So blur what ought to be at best an imperfect mitigation defense from murder to manslaughter into a perfect defense that would lead to a criminal acquittal and then some indeterminate institutionalization on the part of their client, which could be very short. I mean, in theory, the only person that Michael Barisone was ever a threat to were these people torturing him. He never presented as a threat to anybody else. So to the extent he's not exposed to them, he's not a threat to anybody, and presumably could simply be released from institutionalization in short order. So it sounds like that's what the defense is going for here. Now, I'm going to play for you when I start today's direct. I'm actually going to play those last few seconds of the direct questioning of the psychiatrist by the defense counsel from yesterday. Then the judge reads some limiting instructions to the jury. These expert witnesses, they're not allowed to simply announce ultimate findings of fact. That's the role of the jury. The psychiatrist can't just say he is legally insane or was legally insane at the time of the shooting. The jury has to come to that conclusion if that conclusion is going to be reached. So I expect that's the limiting instruction that the judge is going to read to the jury here before the direct examination, the cross-examination by the state, by prosecutor with the interesting name Christopher Shellhorn. Sounds like a children's book name, but nevertheless, he's a real-world prosecutor. Looks like he's about 12 years old, but that's just because I'm old, I guess. Appears quite competent, by the way, through the course of this trial. Looks like appears to be a very good prosecutor. Has his act together, knows his stuff, and is doing a very good job. But now we'll have the cross-examination by psychiatrist, defense psychiatrist Stephen Simring, by prosecutor Christopher Shellhorn, and see what Shellhorn can get out of this defense expert witness on cross to undermine that the apparent narrative they're trying to push, that what might appear reasonably enough to be imperfect self-defense, I think that's on the table, and parlay that into an insanity defense that would lead to an acquittal. So that's where we are at the moment. As always, folks, let's see, this should be running live on the Law of Self-Defense members website. I'll load that up. It should be running on our Rumble account. And by the way, all these social media things, folks, you can find us always at lawofselfdefense.com/ whatever the social media is. So lawofselfdefense.com/YouTube/Facebook, /Rumble/Locals/ Substack/Spotify, whatever social media platforms you use, lawofselfdefense.com/ the name of the social media platform, and you'll find us there. It is airing on the Law of Self-Defense members dashboard. If you're a Law of Self-Defense member and you have questions about today's live show, I encourage you to post your question there. Those are always answered, guaranteed. On Rumble, I'm not exactly sure. Let's see. Is this working? It looks like it is working. So Rumble appears to be working as well. I'm not exactly sure how Rumble works, to tell you the truth, but if you do I think it's called the Rumble Rant, is the equivalent of a super chat on YouTube. I'll do my best to answer those questions. And if you're watching on YouTube and you'd like to ask a question that I can answer, you just need to do it as a super chat, and I'll check those from time to time. With that all out of the way, let me do I know we have not quite 200 people here. Let me go ahead and do the introduction video for today's show. Then I'll do a quick mention of our sponsors, and we'll jump into the meat of the cross-examination of defense psychiatrist Stephen Simring. Here we go. Hey, I'm back. All right. So before we jump into things, I am obliged, of course, to mention the sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to cover its members' legal expenses if the member is involved in a use of force event, and those expenses get big and get bigger fast, folks. If all you've done is make someone aware that you have a gun and you're prepared to defend yourself, you've technically checked all the boxes for aggravated assault with a firearm. That's good for 10 to 20 years in most states. If you are prosecuted on that charge, you would, of course, raise the legal defense of self-defense, but your attorney is going to want a retainer of $30,000 to $50,000 for pre-trial work. That doesn't cover a trial. If you've been compelled to kill somebody in self-defense and are facing a charge of manslaughter or murder, it's easy to burn through $200,000 before trial. That doesn't cover the trial. So if you don't have that kind of money stuffed in a mattress, just in case you're obliged to defend yourself or your family against criminal predation, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because really it does. Now, I've looked at all the companies that offer these kinds of services, as you might imagine, and I have found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can save 10% off the first year of membership with them using the discount code LOSD10. That's LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCW Safe. I'd also like to mention our Hard to Convict webinars. This is a series of webinars that we're putting on over the course of April and May. We did the first of these just yesterday, and it was a huge success. It completely sold out. We had a lot of great feedback, a lot of great questions. The after event ratings feedback form that we sent out to everybody was just stellar. I had a great time. I thought it was a really good webinar, really compelling piece of work. Frankly, I'm proud of it. I thought it went really, really, really well. We got our message across very clearly, and clearly people were amenable. The participants were amenable to that message. So I thought, obviously, sounds self-serving, but I thought it was awesome. Yesterday's Hard to Convict webinar. The good news is we're doing not just one, we're doing a series of these that you can sign up for. They're all the same, so please don't sign up for multiple ones. Just one would be enough. They're 100% free. They're under 2 hours. We don't charge anything for these. It's not too much of a time commitment. And in the course of the webinar, we not only bust a series of common self-defense law myths, the kind of myths that, if believed, are a fast track to a prison cell, we also show you a strategy for how to transform yourself from your probable current state of being easy to convict if you use force in self-defense, to being someone who would be extremely hard to convict. if you're compelled to use force in defense of yourself, your family, or your property. And that's what we want for all of you, for everyone in the law self-defense community, is to know how to make yourself hard to convict. And we can show you how to do that. We explain all that in our Hard to Convict webinar. Of course, yesterday's webinar is over, but we have more webinars scheduled over the course of the next few weeks and through the month of May, actually. And if they continue to be this successful, I imagine we'll continue doing them. These webinars are free. We don't charge a penny, but they are hard limited to 100 participants each. Yesterday's sold out fast. The next one will sell out fast. The next one is scheduled for, let me take a quick look here, for next, not this Saturday, but the following Saturday, April 16th. So Saturday, April 16th is the next Law of Self-Defense Hard to Convict webinar. Then we have another one the following Wednesday on April 20th. If you're at all interested in learning how to be hard to convict while defending yourself effectively, defending yourself and your family decisively, then I would encourage you to make the modest investment of less than 2 hours and 0 pennies, 100% free, in one of our upcoming Hard to Convict webinars. You can learn more about them and sign up for your free seat at lawofselfdefense.com/hard to convict. All right, folks. Let's see. Here am I. Let me pull up yesterday's proceedings. We're going to start with the final few seconds of the direct examination yesterday. That looks like the right image there. This is where defense counsel is wrapping up, and he asks the psychiatrist, did, in your professional opinion, to a reasonable degree of medical certainty, did Michael Barisone know right from wrong at the moment he shot Lauren Kennerak and shot at Robert Goodwin? And this psychiatrist will answer, he did not. He thought he was defending himself from them. Apparently, he had subjectively genuine but objectively unreasonable fears that they were intending to kill him or cause him serious bodily injury. There was, in fact, no evidence of that. But given his mental state and their other torture of him mentally and psychologically, he'd come to believe that, even if irrationally. So that's the closing. Then we'll have the in limine, the evidentiary limiting statement instruction charge. Sometimes it's called a charge. That's not a criminal charge, folks. When we talk about charging the jury, it just means instructing the jury. Given by the judge in this case, that's Judge Stephen Taylor, who I know has gotten a lot of criticism. I don't know he has. I'm told he's gotten a lot of criticism over at some alternative legal website called Law and Crime, something on the margins of the internet. I don't know if you've heard of it or not. Apparently has a handful of viewers there. But apparently the chat comment there was, at least it's been suggested to me, that the chat at Law and Crime was sufficiently negative and hostile towards Judge Taylor that he's ordered the Law and Crime chat shut down, which Law and Crime did. Hey, if I get an order from a judge, I'll follow it too. But Judge Taylor appears not to know who I am, and I've received no such order. So my chat remains quite healthy, folks. So feel free to chat away as you will. For those, I see a comment, is this not live? I am live. If you're watching me live, YouTube should have some kind of little emblem on the screen. If you're watching on April 7th, about just 11:30 a.m. Denver time, I'm live. The video I'm sharing with you of the court proceedings occurred yesterday. Okay, not hard enough to understand. All right, so I think we have everything we need. Let me take a quick look, see if there's any questions in already. Dale is in the Law Self-Defense member site. Thank you. Oh, he says, thanks for hosting a great webinar yesterday. That would be our Hard to Convict webinar. Yeah, Dale, I had a great time. I'm really looking forward to doing the next ones. Hoping to get a bunch of people in there so they too can learn how to be hard to convict. Yeah, I thought it was awesome. So anybody wants to sign up for one of our future Law Self-Defense Hard to Convict webinars, 100% free. You can do that at lawselfdefense.com/hard to convict. Over at Rumble, I don't see anything. Not really sure how Rumble works, to be completely honest. And let's see if any super chats have come in yet so far. Not yet today. All right, let's go ahead and start today's today's coverage of yesterday's cross-examination of defense psychiatrist Stephen Simring. Again, we'll start with the last couple of questions by defense on direct. Did my client know right from wrong at the time he fired the shots? And the psychiatrist says, no, he didn't. He thought he was acting in justified self-defense. Here we go.
Did he know the difference between right and wrong?
I'm sorry, could you?
Did he know the difference between right and wrong?
Are you talking at the time of the
At the
incident?
time of the incident.
Time of the incident, he did not know. He thought he was acting in self-defense.
Did he understand the nature and quality of his acts?
Not clear.
Nothing further.
And that's the end of direct.
All right, members of the jury, before we get to cross-examination by Mr. Shellhorn, I do want to give you certain limiting instructions based on the testimony you just heard. Dr. Simring, of course, was qualified as an expert witness. You've heard that.
Oh, how repetitive this was, that I did not need to know every single post Lauren Canarak did, every time she used the word threat, every time she used the word multiple personality.
Folks, I don't know what just happened there. That's a long crime jump. I would swear when I was watching this yesterday that we actually got into the limiting instruction. Oh, let's see. I'm going to see if I can't get some semblance of order here. Let's see. Let's try that again.
By his therapist, by other people in the past, that there is an underlying depression.
So this is the end again,
Did he know
right
the
from
difference
wrong.
between right and wrong?
I'm sorry, could
Did
you?
he know the difference between right and wrong?
Are you talking at the time of the
At the
incident?
time of the incident.
Time of the incident, he did not know. He thought he was acting in self-defense.
Did he understand the nature and quality of his acts?
Not clear.
Nothing further.
All right, members of the jury, before we get to cross-examination by Mr. Shellhorn, I do want to give you certain limiting instructions based on the testimony you just heard. Dr. Simring, of course, was qualified as an expert witness. You've
All
heard
right, I
that
guess it's
charge
working
from me
now.
twice already. You're going to hear it again at the end when I give my final charge to you, so I'm not going to repeat it a third time now and then have to do it a fourth time. I trust you will call that charge regarding expert opinion and their ability to render their opinions based on information provided to them. And in that regard, you have heard reference to alleged statements made by the defendant in the course of the psychiatric examination by Dr. Simring. These are considered hearsay statements, but they are allowed in this circumstance. You should not consider these hearsay statements as substantive evidence relating to the guilt or innocence of the defendant or for the truth of the matter asserted by the defendant in the statement.
Okay, so just to be clear, when we were hearing direct of psychiatrist Dr. Simring, he was reciting a lot of statements made to him by other people out of court. Normally, that would all be hearsay. It was allowed by the court, not for the truth of the statements. That's what the jury's being instructed here. It was allowed by the court only for consideration as input into the psychiatrist assessment that Michael Barisone did not know right from wrong. So even the psychiatrist is not assuming the claims are true. Basically, he's presuming if they're true, this would contribute to my diagnosis, or at least if my patient believed them to be true, this would contribute to the diagnosis of not knowing right from wrong. His medical conclusion to a reasonable degree of medical certainty. That doesn't mean the statements he recited are true statements. So the judge is making that distinction here.
Rather, I instruct you to consider these statements only for the limited purpose of explaining or supporting the conclusions reached by Dr. Simring, or for assessing the value of the doctor's opinions that are dependent or rely on the defendant's statements. Additionally, I believe you heard a reference from the doctor with regard to the prior alleged criminal history of Lauren Canarak and Mr. Goodwin. You have heard testimony about a background check that was done by an investigator hired by the defendant. The prior criminal history is a purported one. It's unverified. The defendant alleges that this information had an impact on his mental condition, and the testimony was only admissible and to be only considered by you for this limited purpose of explaining or supporting.
So again, the judge is drawing a distinction here between how some piece of information, this criminal background check of Lauren Canarak and Robert Goodwin that Michael Barisone paid for after the relationship became hostile, That evidence of that background check is being introduced only to the extent that it might have influenced Basarone's perceptions, his state of mind, not for the truth of the report. The report could be 100% a lie, factually. So say the report, the background check said Lauren Canarac had 15 felony convictions. That may not even be true. But if Basarone believed it to be true, it might have informed his perceptions and state of mind.
Reporting the conclusions reached by Dr. Simring, or for assessing the value of the doctor's opinions that are dependent or rely on this information. Under our rules of evidence, a jury may consider a witness's criminal conviction in determining the credibility or believability of that witness. We are not here dealing with criminal convictions of Ms. Canarac or Mr. Goodwin. There are allegations of prior arrest. Those are not, under our rules, admissible with regard to the credibility of Ms. Canarac or Mr. Goodwin, and they were not admitted for that purpose. They are only admitted because of the impact that information may have had on the state of mind of the defendant when he received and reviewed that information. That is the only reason that evidence was admissible. It is not substantive evidence of the bad character of Ms. Canarac or Mr. Goodwin. It's not in any way admitted for that purpose and cannot be used by you in your deliberations for that purpose. The only relevance of the evidence is the extent to which you may find it affected the mental status or mental condition of the defendant. That's it. There was also testimony similarly about firearms and possession of weapons by Ms. Canarac, referred to during Dr. Simring's testimony. Again, this information is admitted for a limited purpose, only as to the state of mind of the defendant and how it may have affected his state of mind. That information is not introduced because it may reflect in any way the bad character of Ms. Canarac. That's not the purpose of it. All right, it's only limited information either explaining or supporting the conclusions of Dr. Simring or for assessing the value of the doctor's opinions that are dependent or relied upon that information. All right, so with those limiting instructions, I'll charge you again later at the end of the case on the limits of evidence, but I wanted to do that now before cross-examination since you have heard the testimony from Dr. Simring. All right, with that, we'll begin the cross-examination by the state.
All right.
Good morning, Dr. Simring.
Good morning, Mr.
Prosecutor
Shellhorn.
Christopher Shellhorn.
Do you ever use psychological tests as part of your examination process?
Yes, but I don't perform them.
So for those of you who think it's odd that the prosecutor is conducting his cross while seated, that is odd behavior in court. Normally the lawyers are standing when they're questioning a witness. But apparently the jury, who obviously cannot be put on camera, their identities are concealed from broadcast, is seated, the jury seated immediately behind the prosecutor. So if he were to stand up and kept in frame on the camera, that would also expose the jurors. That's apparently why the prosecutor is questioning from a seated position. Frankly, I wouldn't like that. If I were questioning a witness, I want to stand up. That's just my preference. It would be nice if they could have found some accommodation to do that, but apparently not.
If I think psychological tests are helpful, I will call upon a psychologist colleague to perform the testing.
So you'd agree with me that even when you do use a psychological test, you would never render a diagnosis based on the test?
No, I would not.
Now, you indicated on direct examination that you rendered your diagnoses using the DSM.
Correct.
I'm just going to refer to it that way. I think at this point now the jury knows what we're talking about. But you would agree that any diagnosis in the DSM.
For those who don't know, the DSM is, you can think of it as an encyclopedia defining various psychiatric disorders, and it's presumed credible for the psychiatric industry, the practice of psychiatry, various mental disorders. It's an authoritative text. Every few years they release a new edition. So there's DSM 3 and 4, and I believe we're up to 5 at this point.
DSM would not meet any particular legal standard.
That is correct. There is, in fact, a statement in DSM at the very beginning that says it in so many words, that no diagnosis equates to any particular legal conclusion.
Would you agree with me that there's no memory disorder that's selected just for criminal behavior?
That is correct.
Now, you indicated that you diagnosed Mr. Barisone with depression disorder and delusion disorder.
Correct.
You would agree with me that depression disorder does not affect a person's ability to know right from wrong?
Well, counsel, that's a complex question. There are all kinds of levels of depression. I diagnosed him with persistent depressive disorder, which used to be called in the DSM-4 dysthymia, and prior to that used to be called minor depression or neurotic depression. It basically is a serious condition. It can lead to suicide, but it is not usually accompanied by psychosis. On the other hand, there are major depression disorders which can involve psychosis and delusional thinking. But that's not my diagnosis.
So in this case, your diagnosis of depression would not have affected Michael Barisone's ability to know right from wrong.
That is correct. I'm sorry, not directly. I think the chronic depression made him more vulnerable to be affected by all of these events, but it would not lead directly to his ability to know right from wrong. No.
Do you recall if you ever wrote that in your report?
I don't recall that I did.
With respect to the delusional disorder that you discussed diagnosing the defendant with, you would agree that a person with delusions could know right from wrong.
Correct.
A person with delusions could understand the nature and quality of their actions.
Absolutely, anything's possible.
And I think you just testified in response to the last question from Mr. Belinkis that it's not clear whether the delusional disorder in this case affected Mr. Barisone's ability to understand the nature and quality of his actions.
Correct.
Now, I know you testified to this already, but
So that's not good for the defense that it's not clear. So with self-defense, when you've raised a legal defense of self-defense, in every state, all 50 states, the prosecution then has to disprove self-defense beyond a reasonable doubt. Of course, it's questionable whether self-defense has been properly raised in this case, whether there is more than zero evidence on each of the required elements of self-defense. With the insanity defense, it's more of a traditional affirmative defense in which you not only have to raise it initially, but the burden often, and this does vary by state, and I'm not sure how it applies in New Jersey, but traditionally the burden remained on the defense to prove insanity by a preponderance of the evidence. The burden traditionally was not on the state to disprove insanity once insanity was raised, as would be the case with self-defense. Once self-defense is raised, burden on the state to disprove it beyond a reasonable doubt. Once insanity is raised, you're allowed to argue insanity in court, but traditionally the burden was still on the defense to prove insanity by a preponderance of the evidence. If it's not clear or not, that's not preponderance of the evidence. That's not even close. And for those, I see someone in the comments saying the DSM, that's that encyclopedia, authoritative encyclopedia of psychiatric disorders, got woke. Yeah, that happened to my knowledge, about a decade ago. And that was the last time I started using it for professional purposes. But yeah, it got pretty woke.
delusional disorder is a relatively uncommon psychiatric illness.
Correct.
Some general questions, doctor. Would you agree with me that two people can have the same experience but perceive it differently?
Certainly.
You'd agree with me that someone being mistaken about something is not the same as someone having a delusion?
Yes, in fact, in the definition of delusion, one of the defining points of delusion is it's not based on simple ignorance or on cultural factors. So just for an example, if a child believes in Santa Claus, that's not a delusion. There's no Santa Claus, but it's not a delusion because it's held within the realm of children. If a person believes in God, whether or not God exists is not the point. There is a wide variety of people who believe in God. Delusions are idiosyncratic. They're believed by the individual with little, if any, evidence, and they're held onto firmly. And the final point is the individual with the delusional disorder cannot be reasoned out of it. Simple mistake or simple ignorance will lead to conclusion. You see something and you believe that your partner is cheating you out of money, but when you're shown the books and shown the evidence, you say, oh, that's not true, I was wrong.
Okay, so this is worth speaking to because we're talking about subtly different things here. So say, for example, you have a misunderstanding of self-defense law. You've been taught that if you see someone stealing your car or stealing, you're at a Starbucks and they grab your laptop and they start running out the door with it, that you're allowed to shoot them to keep them from escaping with your property. Now, maybe in Texas that would be true, but let's pretend it's not true anywhere. In fact, let's assume for purposes of this discussion that the use of force in defense of mere property in the absence of an imminent threat to a person, the use of deadly force is not permissible. But you believe it is. You believe as a factual matter that it would be lawful for you to shoot that thief running away with your laptop. That's a mistake of fact. If you do that, you'll be found guilty for an unlawful use of force because, in fact, the law does not permit that. That's different than imperfect self-defense. Imperfect self-defense would be when you're You have an objectively unreasonable view of what's happening. But if you were right, if you were reasonable, that would be a basis for self-defense. So you're imagining that it's not someone running off with your laptop. You're imagining it's someone pointing a gun at your head. Let's a clear example. You're imagining that someone reaching into their pocket is about to produce a gun. Well, absent any actual evidence to support such an inference, that would be an irrational belief. Now, if you were right to believe that, if you had evidence from which to make that inference, well, then you might be acting in reasonable self-defense to shoot that person. But absent evidence from which to make that reasonable inference, that would be an objectively irrational perception of the threat. That would be imperfect self-defense, and you might qualify for that mitigation from murder to manslaughter. In the first scenario, where you were simply mistaken about what the law allows, there is no mitigation. You simply don't have self-defense of any form, and you're guilty of the underlying unlawful use of force.
Delusional disorder, you could put all the evidence in the world out there. The delusional person will hang on to his or her delusion.
I think you just used the term idiosyncratic. Can you just define kind of how you use that word for the jury?
I forgot the context in which I used it, but idiosyncratic means highly personal, that other people don't quite see it that way.
And I think you used it in the context.
Also relevant, right? Idiosyncratic sounds a lot like objectively unreasonable. You saw it that way. The defendant saw it that way, perhaps, but other people would not. Well, the other people are presumably the objective, the hypothetical, reasonable and prudent person. So if they don't see it that way while you do, you're being objectively unreasonable. And of course, objective reasonableness is one of the required elements of self-defense. It's half of the element of reasonableness. The element of reasonableness includes both the requirement that you had a subjective, genuine good faith belief in the need to act in self-defense, and that that belief was objectively reasonable.
Of a delusion would be highly idiosyncratic. It would be unique to that person.
It is. Now, the content may not be, because people who have delusions often have themes which are common themes, like the theme in delusional disorder, persecutory type, the theme that you're being spied on, poisoned, in danger, set up for murder. These are common kind of themes, but each individual who's delusional will have his or her own idiosyncratic take on it.
Doctor, would you agree with me that a person feeling an emotion is not the same as a delusion?
Well, we all feel emotions, of course.
And we're not all delusional.
No, we all feel emotions, and sometimes our emotions get us into a great deal of trouble. Very common that normal people will believe that, I don't know, their girlfriend cheated on them, or their business partner cheated on them, or their driver cut them off deliberately. This is very common. They may even act on it. They may even do violence. However, in the long run, they don't persist. When they're confronted with the evidence, they will back off. Mr. Barisone would not back off despite any evidence. And despite the fact that when I mentioned before about being spied on, he was being spied on. I mean, there were cameras out there. But that's not the point. He thought that this was a plot, a multifaceted plot, all designed to bring him down.
And my question wasn't necessarily specific to Mr. Barisone. It was just a general question that a person feeling an emotion doesn't necessarily mean that they're delusional.
I would hope not. I feel emotions every day.
I hope you're not feeling any emotions with me yet, Doctor.
Only positive and admiring.
So
And I mean that genuinely.
So let me ask you some questions about the discovery that you reviewed in this case and your evaluation. You indicated that you had met with Mr. Barisone for 5 meetings,
Correct.
and the first meeting was in person. The other 4 meetings were on Zoom.
Correct.
Do you recall approximately the total number of hours that those meetings were?
It totaled a number of 6 hours in all. That's written on the first page of my report. I believe the first session was 2 hours and the others were an hour each. So that would add up to about 6.
And your first meeting with him was on September 6, 2019?
That's correct.
And then
Which is just about exactly a month after the incident.
almost exactly a month after
Yes.
the incident. And then your next meeting with him, can you just clarify from your report whether your next meeting was in March or April?
April, all the other meetings were in April.
Okay, so on the first page of your report where it says March 13th, that should be April 13th.
That's a typo.
Okay.
That's a typo. It should be April 6th, April 13th, April 20th, April 27th. The reason so much time went by is I needed more discovery material. So when I had the discovery material, I broke this down into meetings.
Now, for example, after you received the discovery material, I think one of the people you said you reached out to was Ann Picardo.
Correct.
and you indicated that you were aware that she was the defendant's psychotherapist for periods off and on during the years.
Correct.
Ms. Picardo is not a doctor, to your knowledge?
To my knowledge, she's not. No, she's certainly not a physician, and I'm not sure she has a PhD. And I have not seen her curriculum vitae. As far as I know, she is a psychotherapist.
Now, you didn't review all of the available discovery in the case, did you?
God forbid.
Was that because it wasn't provided to you or because you didn't want it or need it?
I was choking on it. I told Mr. Belinkis, please stop. I've seen enough. I mean, I reach a point where you can get the pattern of things without seeing every little thing. And that really got to the whole point of Mr. Barisone's problem. He would dig up every tiny little scrap. I didn't need it and didn't want it.
Well, and I wanted to ask you in particular about witness statements. I think you indicated on direct examination that you reviewed a number of witness statements.
Correct.
Did you actually listen to the recordings of those witness statements, or did you read police reports that summarize this?
Read police reports and might have read a couple of actual statements, but I did not listen to tape recordings. No.
And you were aware that there were a number of people that were listed in the discovery whose statements were not summarized in police reports.
I believe that's true. I'm not absolutely sure. There were a lot of people on the farm, a lot of young people, older people on the farm.
So on the pages in your report where you talked about witness statements, starting on page 6, those would be summaries based on your impression of what a police officer wrote in their report?
Correct. For the purpose of constructing a report, it's important for me to summarize, and hopefully the summary is accurate. But in order to digest all of this kind of information, put it into a readable form, and to extract the essence of it, I will summarize things. Also, to demonstrate my understanding. So if my understanding is faulty, then you can easily see where my summary misses the point. Now, obviously, a summary doesn't cover everything. Hopefully, the summary is accurate.
So if the summary that the police officer wrote in the report was very short and didn't encompass everything that was talked about during the statement, you wouldn't know that?
That's correct. And there are also multiple police reports.
You also indicated, and I apologize, I don't know what it was marked as, but that you had reviewed some written statements from Mr. Barisone.
Yes.
And I think you said that was 91 pages that he provided to you.
Well, he provided thousands of pages. And the deal I struck with Mr. Barisone, I'm putting it kindly. I told Mr. Barisone, I'm not even going to look at it unless you give me the 100 top hits, because I don't want more. I don't need more. I don't want more. You know, there's such a thing as sowing confusion with too much material. So what he did is he complied, and he gave me a document which consisted of 91 pages.
Hey, folks, I just wanted to clarify a point. I had mentioned earlier when I was talking about the burden of proof on the insanity defense that I shared with you the traditional model for the burden of proof, but I wasn't sure if New Jersey had stuck to that. States can change where they place the burden. So, for example, traditionally, back in the day, decades ago, self-defense was a traditional, what we would call an affirmative defense. I don't like that phrase because it doesn't mean what it used to anymore. But traditionally, an affirmative defense meant two things: that the defense had to be initially raised by the defendant. So he had to produce some prima facie, more than zero evidence to get the defense into court in the first place. And that the burden of that, and that's called the burden of production. How you get a legal defense, a legal argument into court in the first place is the burden of production. The burden of production for an affirmative defense is on the defendant. They have to produce that initial more than zero evidence to get the legal argument into court in the first place. Applied to self-defense, that means the defendant has to meet their burden of production on self-defense before they can argue self-defense in front of the jury. Once they've done that, traditionally, the burden of persuasion, the burden of persuading the jury of the truth of that defense was also on the defense by a preponderance of the evidence. So affirmative defense had two burdens on the defendant: the burden of production and the burden of persuasion, where the defendant would have to prove self-defense by a preponderance of the evidence. That's not true anywhere in the 50 states for self-defense anymore. So that's why I don't like referring to self-defense as an affirmative defense, because it doesn't fit that traditional definition where both the burden of production and the burden of persuasion were on the defendant. Today, in all 50 states, the burden of production is on the defendant. But once the defendant has met their burden of production, the burden of persuasion for self-defense shifts to the state, and the state has to disprove self-defense beyond a reasonable doubt. That's not the traditional definition of an affirmative defense, because now the burden of persuasion has been shifted to the state. With the insanity defense, it was a traditional affirmative defense. So the defense had the burden of production, that initial prima facie case to make before you could argue insanity in front of the jury in the first place. And the defendant had the burden of persuasion to prove insanity by a preponderance of the evidence. I wasn't sure earlier whether or not New Jersey kept that traditional affirmative defense definition of the insanity defense, where both burden of production and burden of persuasion were on the defense, but I checked in the meantime. And in fact, New Jersey does keep that traditional affirmative defense definition for insanity defense. So both the burden of production and the burden of persuasion are on the defense for insanity. The defense here, if they're going to argue insanity to the jury, has to prove, the defense has the burden of proving insanity by a preponderance of the evidence under New Jersey law. So just wanted to clarify that for all of you.
They're not numbered. They're basically chronological. Mr. Malinkus and I went over them, and we developed our own little dates numbering system so that I have easy reference to them. But 91 pages, I think, fairly summarizes his concerns.
And so that would just be what Michael Barisone.
I see Mike Brogan is complaining about typos in my book, The Law of Self-Defense Principles. Mike, could you share your book with us? The one that has no typos in it? I'd love to see it. Sure, I'll wait.
wanted you to know about his take on what happened within the confines that you gave him.
Well, I had everything, but I instructed him to do that. I didn't want any more. And I read enough to know how repetitive this was, that I did not need to know every single post Lauren Canarak did, every time she used the word threat, every time she used the word multiple personality, every time she used the word, I wasn't interested in that. I'd seen so much of that I got the idea, and that I wanted him to summarize. Also, while it may be a biased summary in the sense that he chose it, it's an important bias because this is what's important to him. And in my thinking, what really mattered about the discovery is not the fact of it, but what was important to him about it. So by having him digest it, I saw what was important to him.
So if he put something into his written statement that wasn't accurate, that wouldn't matter to you?
Well, in the sum of that, no record is completely accurate. But my review of the records that I saw and his summary comported with one another. And it was not really for the truth of anything. I was really saying to him, basically, go through these thousands of pages, pick out 100 pages, the ones that most affected you. And that's what I was interested in, what most affected him. And that's what he gave me.
I guess maybe asking that question another way, would you agree that if the information you were provided was inaccurate, that could affect your diagnosis?
Anything's possible.
So, for example, you were asked on direct examination about various text messages and media documents that Mr. Barisone told you about.
Yes.
And he told you that he was aware of those media posts or those text messages before the shooting incident.
Yes, he was following them avidly.
And so he was following them almost in real time, you said, in that weeks or week leading up to the shooting.
Consistently following her posts.
Now, I'm going to show you in that regard, if I may approach, Judge.
Sure.
What was referred to as Exhibit 200A-85, Doctor.
Got it.
Do you remember that post?
I think I was shown this by your adversary before. This comes under
Adversary.
The tab. They know the war is
That's
coming.
true.
And where it has a pink highlighter around a certain post, who put that there?
Oh, I don't know who put it there, but it says author Lauren Canarak. This was on 7/28/19. That would have been a week before the shooting. And the text was, they know a war is coming.
And your recollection is that Michael Barisone gave you this post in particular and told you that this informed some of his mental state.
But this was part of a vast number of things. I've seen that quote, and I've seen similar quotes riddled throughout these emails.
But I think your testimony on direct, correct me if I'm wrong, was that you were shown this particular text or that this was a particular one Mr. Barisone referred to.
One of them is
And that's, if you would agree with me, that's on page 18,356 of the records.
18,356. That is a lot of pages.
Do you know where this post came from, Doctor?
No, it looked like, no, I think she had Instagram as well as Facebook. I don't know all the social media she used. I think her primary social media was Facebook. She texted, she used a lot of social media, but 18,000 pages is a lot of pages, even in a case like this.
Would it surprise you that this came from Facebook sent records and this came from the actual records Facebook had?
Why would that surprise me? Not at all.
Would it surprise you to know that it's in a section called private messages between account holders?
No, it wouldn't surprise me. I don't know.
So if Michael Barisone gave you this and said he relied on this posting or text message This isn't something that would have been public at the time before the shooting.
I have no idea. This is one of 18,000 pages. Most of it's public.
And this is something, are you aware whether this is something that was turned over by the prosecutor's office to the defense in discovery?
Of 18,000 pages, I cannot account for each one of those pages. They're in evidence. I don't know anything more about that. And I certainly did not read all 18,000 pages.
I'm just trying
Nor
to,
will I.
and doctor, I'm just trying to get to the heart of Michael Barisone told you things. You didn't verify or corroborate everything that he told you.
I'm sorry, corroborate in terms of what?
Well, you said that he told you that he relied on a number of Facebook posts
Yes,
that informed his state of mind.
yes.
And you said that he told you about this particular Facebook post as a post that informed his state of mind before the shooting.
One of many, many, many. Certainly, I did not believe that a war was coming.
And so what I'm asking you is, if he wasn't actually aware of this post before the shooting, does that affect your opinion about what he told you?
No, because he was aware of 17,000 other ones, which was similar. I'm just making up that number, given 18,000 on that. So
was
it's
gonna ask you that question
17,000.
next,
It's
Doctor. So-
17,000 less one. Doesn't change anything.
You were also asked about these posts, and I'm going to show you what were marked as Exhibit 200A 83,
Yes,
200A 81,
these are the manifestos.
900E6,
I've read these manifestos over and over again.
and 900E7.
Counsel, these are the manifestos.
And I'm not going to ask you to read them again unless you want to, Doctor.
Oh, please,
But you indicated that those were given to you or referred to by Mr. Barisone,
many times.
and you referred to them as the manifestos.
Yeah, they're labeled manifesto. I'm not sure that was her word. Well, now I can't even remember any longer where this word came from.
Do you remember when you testified on direct examination that Lauren Canarak called those
I
manifestos?
think she did, but I'm not sure.
Would it surprise you to know that she never used the word manifesto in her records?
I wouldn't be surprised.
Doctor, this is probably a small detail for the purposes of what you were asked to evaluate, but on page 5 of your report, did you indicate that the police officers responded to investigate on Wednesday, August 7th, 2019 at 4:13 p.m.?
Yes, that's what I wrote.
And are you aware that the actual time that they responded was 2:13?
It probably was a typo. There's several typos in my report.
I'm not going to go through all of them. Doctor,
Typos, typo
but
gate,
staying on page 5.
just like my book.
You would agree with me at the bottom of that page, it's talking about Mr. Goodwin and his statement.
Yes,
And that
Michael
leads over
Barisone
onto
didn't
the
kill
top of page
anybody.
6 where there's a
He
block
was
quote of
shot
approximately
Lauren
5
Kenner
lines.
twice in the
yes, that
chest, shot
actually
at
is
Robert Goodwin, 2 counts of
inappropriately
attempted
attributed.
murder,
It was
not
actually
murder.
Lieutenant Heiner's statement that came from the report.
So that's not accurate in your report.
Typo.
Now, you also reviewed a number of medical records in this case,
I did.
and those would have been Ms. Canarak's records as well as Mr. Barisone's
And Mr. Goodman.
and Mr. Goodwin's. You indicated that Mr. Barisone sustained a dog bite on his left eye.
I think thigh, and I think it was in his groin area. I might have written that. As I recall it, I think it was in his groin area.
Okay. That was going to be my next question, doctor. Is on page 9, it says he had an apparent dog bite in her left eye.
You're embarrassing with my typos.
I just wanted to make sure you were looking at the right medical records.
The right part of the body, right.
So the bite, as you recall it, was in his on his leg,
It was his
not
groin,
on his eye.
his groin area.
Now, you were aware.
Oh,
as you
Rosie went
testified
right
on
for the
direct,
groin.
that DCP&P sent a caseworker to the property on August 7th, and you're aware that the caseworker was there to investigate a claim of child neglect.
That's my understanding. Child neglect and child abuse, yes.
Now, you also indicated that the report.
Just to clear up typo gate, folks, I'm sure my book has its share of typos. I can also assure you that none of them have any substantive consequence. They don't reverse any claim of law or representation of law. There it goes. Anybody wants to do a free edit and let me know all the typos in the book? You have that kind of free time? More power to you.
Was anonymous. Were you aware from reviewing the records that it was actually a report from Safe Sport?
Later, I read that it initiated with Safe Sport, which is the sporting governing body. And I know as a fact, everybody in this profession belongs to Safe Sport. Most legitimate people belong to Safe Sport. And it's my belief that Lauren Canarak filed a report with Safe Sport to file a report against Mr. Barisone, making more claims by the vehicle of Safe Sport. What I meant by anonymous is that the actual complainant wasn't identified as Lauren Canarak or anybody else. It's my experience with Child Protective is they do not reveal the names of complainants. That's very common. But I do believe it was filed via Safe Sport. It's my understanding that Lauren Canarak had reported.
You don't have to
Him
say
to
it again,
Safe Sport.
Doctor, thank you. But are you aware that the complaint was actually against Michael Barisone and Ms. Ray?
Yes, I think so. It's her children.
Now, you indicated earlier, I think, that you summarized some of the witness statements in your report.
I did.
And I'm going to show you one of the reports. Because this doesn't have an evidence sticker on it, but if I could refer to this as S147, it is marked for identification.
Show it to counsel, please.
Doctor, I know you said there was a lot of discovery in this case, so I won't ask you if that is definitely one of the reports that you read.
So just to remind everybody, what the prosecution, what they need to do here is they're not trying to make Lauren Canarak or Robert Goodwin look like nice people. That would be impossible. But what they're trying to show is that the evidence here does not reach the threshold of insanity in the legal sense, that he simply didn't know he was shooting a human being, or even necessarily imperfect self-defense, that he had a genuine but objectively unreasonable belief in the need to shoot. Although I'm sure the prosecutor, he'd probably be amenable to a manslaughter conviction if it came to that. I mean, they offered a plea of 10 years early on. Frankly, the gun charge alone was good for 10 years. It's insane. Maybe that's the insanity. Insane that Michael Barisone didn't take the plea. He was going to do 10 because there's no defense to the gun charge. It's just a possession charge under New Jersey law. He was clearly in possession of the gun. So, and we know who gave it to him. I mean, so he was going to do the 10 no matter what. May as well take the 10 and don't put yourself at risk for a life sentence for attempted murder. But here we are. Yeah, New Jersey gun laws are nuts. I mean, listen, as far as I'm concerned, they're all facially unconstitutional. I believe all gun laws preemptively applied to law-abiding, mentally sound American citizens are all unconstitutional. But I assure you, New Jersey will impose them on you and put you in jail if you violate them, regardless of their unconstitutionality.
Let me just see if I can readily lay my hands on that.
By the way, folks, there's exactly 300 of you here at the moment. If I could remind all of you to please hit that subscribe button if you're on YouTube. That's a big help to us. We just broke 30,000 subscribers, and it helps fool YouTube into sharing our content more broadly, helps us grow the law of self-defense community. The same if you leave a comment, even if it's just your city and state. That fools the algorithm. If you could hit that thumbs up like button, that would also be appreciated. And even if you subscribed in the past, folks, YouTube unsubscribes people without informing them all the time. So if you could just, I know it's only $1 every time you hit that subscribe button, but if you could give me one more hit on that button, that would be appreciated. Thanks, guys and gals.
It's a report from Morris County Prosecutor's Office by Sasha Gold. I do remember that name. And I did review that report, yes.
Doctor, I'm going to refer you
It's
to
Sasha Gould. There were two Goulds investigators. So I remember this is Sasha Gould. There was a male Gould as well.
That's right. And Doctor, I'm going to refer you to page 5 of that report.
Right.
Approximately, I would say 2/3 to 3/4 of the way down. It's actually the third paragraph from the bottom that starts with great.
To be clear, to the extent we're arguing insanity defense here, the burden's not on the state. The burden is on the defense to prove insanity by a majority of the evidence.
Stated that on today's date.
Yes.
And you see the sentence that says it was learned that someone from her house reported allegations of abuse against Gray's children by Barisone.
Correct.
And this is in reference to Detective Gould's summary of her interview with Ms. Mary Haskins Gray.
Correct.
And you relied on that summary in formulating or adding information to your report.
Well, just a moment. You said this? Yes, that's right. This report by Investigator Gould, she spoke to both Mr. Barisone and Ms. Gray. This statement specifically relates to Ms. Gray. I just want to identify the statement. So could you repeat your question?
And just before we do that, you just said that Detective Gould interviewed Mr. Barisone and Ms. Gray, but I think you meant she interviewed Mr. Goodwin.
Mr. Goodwin, sorry, Mr. Goodwin. Right, Mr. Goodwin and Ms. Gray.
So the sentence I was referring to was, it was learned that someone from her house reported allegations of abuse against Gray's children by Barisone.
Yes.
And then if I direct your attention to your report, page 8, and I'll refer to your report as S423. I think it's the same as the one the defendant marked.
Yes. I have it.
That's page 8
Of my report.
of your report.
Yes, I have it.
And does the very last full sentence on that page say, it was learned that someone had reported allegations of sexual abuse against Ms. Gray's children by Mr. Barisone?
Correct.
So you'd agree with me, the only difference between the sentence you wrote in your report about Ms. Gray's interview and the sentence that Sasha Gould wrote in her report about Ms. Gray's interview is that you added the word sexual before abuse.
Oh, yes, this does not say sexual. I think that came from something else, but I don't remember. This does not say sexual.
So beginning on
When you say
page-
this doesn't say sexual, what are you referring to?
Your Honor, the statement by Investigator Gould that I was quoting
All right.
said abuse does not say sexual abuse.
Okay.
So when you indicated earlier that you summarized certain witness statements in your report, I think you said that that was to give your understanding of what some of the witnesses said as it may have pertained to your ultimate opinions.
Yeah, yes, correct. It allows you to point out the error that she did not say sexual. So I laid out my understanding, which in terms of the word sexual was not correct.
So you added the word sexual into your report where Ms. Gray never said that in her statement.
I don't know if she ever said it or never said it, but that doesn't appear in that particular statement. And I did not add it deliberately.
And that's because you never listened to her statement or watched her statement.
Correct.
So you added it perhaps inadvertently, I guess you're saying, based on something else you saw in the case?
I think so, yes.
In fact, in those written statements of Michael Barisone, does he continually say that the DCP&P was there for something related to sexual abuse?
I think so.
So Michael Barisone told you in his written statement, or wrote in his written statement, that the worker was there to investigate sexual abuse, and then you adopted that in your report.
Not really. It's my experience, counsel, in working with DIFAS over many years, now DCP&P, is that they provide minimal information. And they will just simply say a complaint has been filed. They won't say by whom. They often don't even say the type of complaint. And I don't know why sexual crept into this. It certainly doesn't reflect what Investigator Gould said. It does reflect what Barisone said. I really don't know the answer to that. But I do know that some kind of complaint was filed, and I don't know who initiated it. It came via the Sport Safe professional organization, but I don't know who initiated it. Mr. Barisone assumed that it was Lauren Counteract with one more attack against him, but I have no way of knowing that.
And I think you said you don't know where that word sexual or where the sexual abuse came from, why it got inserted here.
Correct.
But you would agree with me, based on what we just discussed, the Division of Child Protection and Permanency, DCP&P, was not there to investigate sexual abuse.
I don't know. I'd have to go through this again, maybe in the break, and see the statements that came directly from the investigator, if there was a statement directly from the investigator. I'm not sure I saw anything from the investigator.
What if I told you that that investigator testified in court earlier in this trial and said that she was not there to investigate sexual abuse?
I will accept that assertion.
Would you also accept the representation that the Safe Sport records of the initial complaint do not reference sexual abuse?
If that's your assertion, I will accept it.
So where you indicated that you didn't know where the word sexual came from, you're also acknowledging that that is in the defendant's written statements that he gave to you.
Correct, and I might have conflated it in doing my summary of the report. This is really, as I explained, one of the reasons I lay out my summary, so that if I am in error of anything, it can easily be picked up by you on cross-examination.
It's a good thing I make mistakes.
Things that are intentionally wrong into your report so I can catch them on cross-examination?
Beg pardon?
Is that what you just said?
That's one of the most bizarre things I've ever been asked. No, I lay out my thinking so that you have the opportunity to examine the basis of my report and to question me if I'm in error about one of the bases, as you have. I'm not trying to trick you.
And I'm not trying to trick you either, Doctor. Now, you indicated in your report on page 14 that Michael Barisone told you the last thing he remembers is information from the social worker.
Correct.
Do you recall in that written statement that he gave you, the 91 pages, that he said that there were 2 or 3 images, blurry at best, until being unloaded from the ambulance at Morristown?
If you direct me to the page.
Sure, Doctor. I have it marked as the very last page in those.
So this is a reference
So the
to
record is clear.
the
I'm
defendant
referring to what I've
Barisone.
marked as S.
This is a reference to Barisone having no recollection of the events. So from moments before he drew his pistol purportedly until he was taken out of the ambulance at the hospital, in that intervening period, he claims to have had no recollection of what happened.
440 for identification.
I have it. I call it page 91.
Yeah, I see in the comments that in real
And
time
Dr. I'm
today that
specifically
the
looking
defense
at the
has
end of that
rested and the
paragraph,
state's
And you
calling a
agree with me,
rebuttal
page
witness,
91 is
but
the last page Michael Barisone wrote that he gave to you.
this is really the
That
critical
so-called 100-page
defense
packet, which
testimony
actually
here is whether or not the
91
defendant
Yes,
can
what it
get to
says is-
insanity.
The last 2 images I saw before the lights went out.
It's actually before that, Doctor, what I'm referring to,
Oh.
where it says, I remember being at my desk. I have 2 or 3 images, blurry at best, until being unloaded from an ambulance at Morristown.
Yes, I have. I remember being at my desk. I have 2. Yes,
Did you ask him what those 2 or 3 images that he remembered about the incident were?
I did. And I have a red X over that, which is my notation for meaning he could provide no further information. On that particular 4 sentences, I placed a red X when I go through a statement, which means he could provide nothing else.
So you did ask him, and he responded, he didn't remember what that meant.
Correct.
And that's not in your report. I don't think I missed that, correct?
I didn't have these 91 pages. I had 18,000 pages when I did my report, and I've already told you I did not read all 18,000 pages.
I'm sorry, Doctor, that maybe that wasn't clear. You didn't indicate in your report that you asked him a question specifically about the 2 or 3 things that he remembered that were blurry, and he couldn't.
Correct.
You would agree with me that a person who is feigning amnesia may spontaneously confess to something?
What?
Can you repeat the question?
Sure. You would agree with me that someone who's feigning amnesia may spontaneously confess?
Anything can happen. If the word you're saying is may, anything may happen.
And I'm specifically referencing in the DSM where it talks about feigning amnesia. Doesn't it indicate that an individual who's feigning amnesia may spontaneously confess?
Sure, that can happen.
And these statements that Mr. Barisone wrote that you indicated you relied on, were you with him when he wrote those?
I was not.
Do you recall approximately when you asked for those to be written?
It was sometime after my last interview in April of 2020 when I told Mr. Belinkus that I had so much material that I insisted that he ask his client to prepare a digest for me.
So you asked him to write those after your last interview with him?
Correct. And I said no more than 100 pages. And when he protested, I said no more than 100 pages. If there's anything more than 100 pages, I'm not going to read it.
Do you recall approximately when those 91 pages were produced to you?
Sometime after my last interview in April of 2020.
And you just indicated that after you got those, you reviewed them?
Yes.
And you indicated that at least with respect to the comment about 2 to 3 images that were blurry in his mind, you asked him about those and he didn't remember them.
All I have is an X here. I underlined many things. I do that in red. When I do an interview, I had an X here, which meant he gave me no further information.
So you interviewed him or examined him again after that last meeting of April that's listed in your report?
That's a good question. I did not. That may have come, I might have put that together with some of the original material that he submitted.
So it's possible you didn't ask him about the 2 to 3 parts of the event that he did remember, even if they were blurry.
It's certainly possible, yes.
Doctor, moving on to your diagnosis, specifically the diagnosis for delusional disorder. I think you indicated that a delusion is a false belief.
Yes, a false belief, not based on simple ignorance, not held by any particular culture or subculture, and not amenable to reasonable change.
Did you define the term delusion in your report at all?
He said, probably I did. Starts with false belief, but with those caveats. Yes, on page 18 of my report, this is in the summary section, where I wrote, delusional disorder is a relatively uncommon but severe psychiatric illness. The disorder involves psychotic thinking and a break with reality. That's the same thing, psychotic thinking and a break with reality. Delusional disorder is related to schizophrenia, which is a much more common condition. In schizophrenia, the individual displays a wide range of serious symptoms, including hallucinations, agitation, disordered thought process, and delusions. However, I'm adding, in delusional disorder, the major symptoms involve delusions, not these other things. So in schizophrenia, you have a grab bag full of serious symptoms. In delusional disorder, you just have the delusions. So it's a part of schizophrenia.
Now you,
Well,
you
I'm not
indicated,
finished.
well, my question was just
therefore-
what, and Doctor, my question
You have the delusion disorder, you have the delusions without the outward demeanor that would tell people you're having delusions. That could be used as a cross check on your claim of delusions.
was just whether you defined it, and I think you did answer that. So
Well, I haven't finished the definition.
I didn't ask you to define it. I asked you if you did define it.
Yes, and I was reading you my definition.
Okay, I didn't ask for that.
Okay.
Thank you, Doctor. What in particular is Michael Barisone's specific delusion?
That Lauren Canarac is bound and determined to destroy him and kill him.
When did that delusion start?
I can't say exactly, probably in the summer of 2019.
And what specific evidence do you rely on to show that that was the onset of the delusion that Lauren Canarac was? I don't want to paraphrase, I'm sorry, I didn't get the exact words you used.
Well, the posts and his deteriorating mental state and their deteriorating relationship.
So potentially the posts that Michael Barisone told you about when you met with him,
Correct.
some of which we've established he didn't have before the shooting.
Judge one, not some.
Yeah, you're just one.
Well, I only addressed one, Judge.
Well,
Do you have
but
any
if you have others, then you can address them, but you only addressed one.
I didn't go through them all in the break, to be candid, Judge.
Huh? I understand. But what you did go through, what's on the record is one.
So, Doctor, my question was,
So is the judge still biased in favor of the state? For all the long crime people who think the judge is a horrible monster to the defense?
you indicated that you based your opinion about the onset of the delusions and the delusional diagnosis on the existence of.
Lauren Canarac said she was going to destroy him, not physically. There's lots of ways to destroy people, emotionally, psychologically, reputationally, socially. She never threatened him with physical harm. And people use the word war in a social context. It's got nothing to do with physical harm.
These social media or Facebook posts.
Well, yes, on the deteriorating relationship between Canarac and Barisone, the things they were saying to each other, and particularly and primarily on these posts and texts.
And you didn't indicate in your report specifically when you determined the onset of the delusions.
I think I mentioned in the report that it started somewhere in 2019. I think after she returned from the
Oh yeah, is
Florida
Nick's
and moved back
crowd
to
in
Florida,
favor
New Jersey.
of bias
They
in
had
favor
had
of the defendant?
normal
I haven't
problems
been over at
before that
Nick's in a
time, he
while.
said, normal.
I will be there tomorrow
Landlord
though for
tenant
the
had
Edgecombe.
problems, But after she
sentencing.
returned, things took a decided turn for the worse.
So if I'm reading your report right, are you talking about on page 16, where you indicate Mr. Barisone's relationship with Lauren Canarac and her family began to quickly deteriorate in the spring of 2019?
Correct.
So you wrote that there because you determined that the delusions began then.
Well, they never begin at one particular time. Delusions develop. And if you look at the history of a delusion and you go backward in time, what you'll usually find are suspicions and distrust and feelings about bad will. These are all within the normal intercourse between people. But then they get more out of hand and the ideas become less and less plausible and more eccentric and more idiosyncratic. I think that by the time spring of 2019, Lauren Canarac started saying things which were unmoored from reality, unmoored from what was actually happening. And Michael Barisone was more and more believing the things that she was saying.
And you'd agree with me that the criteria or a symptom for delusional disorder would be that the delusion has existed for a period of 1 month or longer.
Correct.
And so what you're saying today is even though you didn't determine specifically whether it was before a month before the shooting, that's your opinion that it did exist.
Yes, it's somewhere in the spring of 2019. It's very hard to put a specific date on it. But the reason the DSM puts that proviso in is it's to rule out an instance where somebody suddenly claims that all of a sudden today I became delusional about you. That's not the way the disorder happens. It percolates and develops over time. So this is a very typical development of a delusional disorder over time.
Doctor, you testified on direct examination that Mr. Barisone was depressed and preoccupied with Ms. Canarac,
Correct.
and you based that in part on review of the various Facebook posts and social media posts that he told you that he was reviewing?
Well, that, statements by other witnesses, Ms. Ricardo, Mr. Tarshish, Mary Gray Haskins, Ruth Cox, some of the young people on the farm, Justin Harden. I can't name all of them, but there were a lot of people who were interviewed who were seeing the same thing and felt helpless to do anything about it. Everybody seemed to see a train wreck coming, but nobody seemed to know what to do about it.
And they were all preoccupied with what was going on here between themselves and Ms. Kenner.
Oh, not the way he was. They were concerned. That's small potatoes. They were concerned. I'm concerned about a lot of things. I'm sure you're concerned about a lot of things. That's not the same as preoccupied. Preoccupied is having a thought in your head that you cannot get out of your head no matter what. That's a delusion.
So if some of those witnesses, let's say, had testified that they were terrified, or that they were scared, or that they were preoccupied with everything going on, does that mean they were delusional too?
No, it depends. They were certainly preoccupied and frightened because the farm was falling apart. This is their place of residence and their place of employment. And they were all dedicated very, very strongly to a sport in which they shared a common love. And they
Okay. Who cares? As far as the Edgecombe sentencing tomorrow, I actually don't know what time it is. I'm relying on Nick to let me know what time to show up. Sorry, folks. It's a very busy week for me. I have a lot of balls in the air. So whenever Nick tells me I need to show up on Ricada Law's channel, YouTube channel, for the sentencing is when I'll be there. If any of you find out that what time the sentencing is scheduled for, feel free to let me know. I would appreciate it, but I don't know myself.
They also shared a great deal of affection for Michael Barisone. That came out. They saw everything unraveling in front of their eyes and felt helpless to do anything about it. This had to do with Mary Haskins Gray and Ruth Cox, and I think that's one of the reasons Ruth Cox came to visit. Had to do with Stephen Tarshish, had to do with Justin
Nick's
Harden.
likely to be
People
late.
saw from their point of view that things were going very badly, and they did not know how to intervene.
Now, you didn't review all of their statements.
Counselor, I would still be in my office today if I were reviewing every one of the statements. I took what I thought was a fair sampling.
So if somebody said something different than what you just testified to, that could affect your opinion.
It has to do with the overall thing. If one kid on the farm said, gee, things look pretty happy, that's not going to change the overwhelming weight of evidence.
What if all of the people felt the same way and expressed their concerns the same way that Michael Barisone did?
Well, if
You're saying
everybody,
that their own fears or their preoccupations were somehow less than Michael Barisone?
well, this is sort of a hypothetical thing, but if you're saying if Justin Harden said, I felt personally threatened that she was going to kill me, if Stephen Tarshish, attorney, said, I was personally threatened that she was going to kill me, well, that might be different, but nobody said anything like that. They were concerned about Barisone's welfare. There wasn't anybody else there that felt personally and directly threatened by Canarak and Goodwin.
Based on your review of what you did review.
That's all I have. And
You
my
were given
interviews.
everything, correct?
I was given more than everything.
You had access to everything. And you chose not
God
to
help
look
me,
at it.
yes, I had access to 18,000 pages. And it isn't just a question of reading 18,000 pages and writing a bill for 18,000 pages. I'm not going to do that. It's not necessary. In doing a review of medical records, it's not necessary to do each one. Things become very duplicative. And after a point, especially when you're experienced in reading records, as I think I am, a pattern emerges. Now, that doesn't mean that on Tuesday, one day, somebody said things look pretty good. That wouldn't change anything. The overall picture was clear. People on the farm were concerned about the welfare of Michael Barisone. They saw the man they really cared for deteriorating, but they were not concerned about their personal safety. It was only Barisone who was afraid that Lauren
None of these other witnesses provided any evidence that Lauren Canarak and Robert Goodwin were physical threats to Michael Barisone. None of them. He was being treated badly by them. They were concerned about his mental state. They were clearly torturing him mentally and psychologically. None of that is a physical threat that would justify the use of deadly defensive force.
Canarak was going to kill him.
He was the only one that was afraid.
Correct. That he was going to be killed by Canarak.
Now, moving on to the question I had about some of the information that Mr. Barisone was collecting. You indicated that he produced.
I'm sorry. It's about, I know we started a little bit late today, so I wanted to go a little bit over, but if you're going
I
to
think
finish
now
up
is a good
within
time.
5 minutes
Now's a
or
good
10 minutes, I'll continue. But if it's going to be longer, I want to give the jury their
How much longer?
fairly
now's a
regular.
good time, Judge.
Yeah, all right.
I'm getting hungry.
All right. Well, that cinches it then, Doctor. We'll break for lunch.
Thank you.
All right. Very good. Enjoy your lunch, ladies and gentlemen. We'll see you around 20 of 2.
All right, folks, I'm going to skip ahead.
Doctor, you can leave all your papers.
Skip ahead the whatever the hour or hour and a half they take for lunch. Thank goodness. All right, and we're back here.
I want to bring in Dr. Simring, please. Good afternoon, ladies and gentlemen. Please be seated. We are ready to resume the cross-examination of Dr. Simring. Go ahead, Mr. Shellhorn.
Thank you, Your Honor. Good afternoon, Doctor.
Good afternoon.
I think we left off before the lunch break. I was going to ask you some questions about your testimony on direct examination related to guns. And I think you had indicated on direct examination that you were aware from Mr. Barisone telling you that there were certain posts or social media references to Lauren Canarak owning guns.
Yes,
And he told you that he was aware of that before the shooting.
yes,
And I think you had indicated that that was part of what you relied on in rendering your opinion or forming your opinion that he was delusional at the time of the shooting.
that he believed a lot of this, and all this led into delusional thinking.
So, of course, someone mentioning guns on the internet is is not the same thing as someone threatening someone with a gun, even if they're threatening over the internet with a gun. I mention weapons all the time. I mention guns in every piece of work product I do on the internet. Every video, every podcast, I close by saying, if you have a gun so you're hard to kill, know the law so you're hard to convict. Does that mean I'm threatening somebody? So the mere fact that a gun is mentioned is not a threat. It would have to be mentioned in a threatening manner, which we're not seeing here. That said, this is New Jersey, and this will be a New Jersey jury. And I've lived in these hyper gun control states like New York, Massachusetts, and people there often, to them, a gun is like a rattlesnake. They often have a visceral, emotional, negative reaction to even the mention of the word gun. So they may, in a typical gun control neurotic fashion, emotionally overreactive fashion, have that kind of response to the mere mention of a gun. But for normal, rational people, the mere mention of a gun is not inherently a threat.
Now, you were aware from your review of the discovery that Mr. Barisone had called 911 on a number of occasions leading up to the day of the shooting.
Yes, at least 4 occasions.
Do you recall, did you listen to any of those 911 recordings?
I did.
Do you recall on the July 31st 911 call, when he was asked whether any weapons were involved or mentioned, and his response was no?
That's correct.
And you recall on August 1st, when he called 911, he was asked if weapons were involved or mentioned, and his response was no.
I believe that, as I recall.
This is 1.25, folks.
And on August 3rd, do you recall that he called 911 and was asked if weapons were involved or mentioned, and his response was, I have not heard a word of that?
Something like that. Yes, those are standard questions, and I believe he answered in the negative.
And lastly, on August 5th, on the call, he was asked if weapons were involved or mentioned, and his response was, not so far.
That's correct. Not so far. That's correct.
Now, Doctor, I think you testified earlier today that the gun that was recovered after the shooting was Ruth Cox's gun.
Correct.
Do you recall in your report that you had said a number of times that you assumed it was Mary Haskins Gray's gun?
If I did, it was a mistake. I think it was Dr. Cox's gun.
And
I think.
If you can refer to page 9 of your report, specifically halfway down the page before the heading that says medical reports.
Yes.
Did you put in brackets there, I believe the gun was a pistol that belonged to Ms. Gray?
I'm sorry. Give me the reference, please.
Yes, sir. It's page 9, the last line before the heading.
Oh, I
that says
have it.
medical.
I think that was an error. I think that it belonged to Dr. Cox.
And on page 14,
So the prosecution's pointing out lots of little mistakes in this psychiatrist reporting of his medical assessment of Michael Barisone. I'm not sure any of them are substantive. It doesn't really matter for purposes of legal argument here for the criminal charges or the legal defenses. Who gave the defendant the gun? That's not particularly important. But if there's a kind of a constellation of errors throughout the report, it can be used to suggest the sloppy work. And if the work was sloppy, perhaps the medical conclusion was sloppy.
did you indicate at the bottom of the page, in the last paragraph, he had in his possession a small pink pistol, which I believe came from Mary Haskins?
Again, I think that was an error. I remembered clearly it was a pink pistol, not to be sexist about it, but it looked like a quote woman's pistol. And it belonged
Not to be
one of the women.
sexist about
I
it.
must have had that mixed up when I dictated the report. I'm almost sure it came from Dr. Cox.
In fairness, I built my wife a pink
So we
AR,
have to go through
so
the exercise again. Would you agree with me on page 17? If it says, I'm not certain when he obtained the small pink pistol, which I believe was owned by Ms. Gray, that would be the same answer.
Yeah, I think it was my error. I think it was Dr. Cox.
it might be
Were
a
you
pink
aware
AR.
when you
Building a
reviewed
pink
the
AR
discovery
for your
that
wife
there were
might be
multiple places where it
sexist,
was
but
referenced as Ruth
it
Cox's
works.
I think so.
gun? You never asked Michael Barisone when he first obtained that gun, did you?
Well, yes, he said that he obtained it. It had been locked up in a safe, as I recall, and he obtained it shortly before he went down to confront Lauren Canarak at where she was living, and he armed himself because he was frightened for his life. And he, as I recall, he removed it from his safe where it had been kept for safekeeping.
Can you show me or tell me where in your report you put that?
That,
Well, so your recollection is that you asked Michael Barisone when he first obtained the gun?
yes, I might be able to find it in my notes, not in the report, or it might be in the police report. I don't remember.
Would you take my word for it that it's not in your report?
Yes, I will.
So your recollection is that at some point when you were interviewing Michael Barisone, he told you that he remembered getting the gun from the safe before he went to the house?
Yes,
And at least for purposes of your cross-examination, you agree with me that's not in your report?
I'm not going to look through it and waste the jury's time. I'll accept your representation.
Did you ask him when he first obtained the gun from Ruth Cox?
From what I recall, she had come up from North Carolina to visit, and she gave it to him for safekeeping, and he put it in the safe.
Would you agree with me that that's not in your report either?
No, that's not in the report. And as I recall, I don't know if it was a licensed weapon, and I think that for safekeeping, he put it in his safe. That's my best recollection of it.
So your recollection from reviewing the discovery and speaking to Michael
Of course, for gun law purposes, again, I think all these gun laws are facially unconstitutional, folks. But as far as New Jersey would be concerned, him taking the gun from the woman and putting it in his safe, locked up in his safe, that's constructive possession by Barisone. I don't do gun law, particularly not New Jersey gun law, but assuming their licensing requirements are on the order of what's required in Massachusetts or in New York in particular, where your firearms, the serial numbers, at least they used to be, have to be printed, individually printed on your permit. That would be constructive possession. And if the possession's unlawful, that's just a crime under New Jersey law, constitutionally or not.
Barisone, is that you knew that Ruth Cox had brought the gun with her from North Carolina, had given it to the defendant for safekeeping. He put it into his safe. He got it at some point before the shooting, before he went to the farmhouse.
Now he definitely has possession.
That's my best understanding, yes.
And none of that is in your report.
Correct.
And you continually attributed the gun to Ms. Gray throughout the course of
Well, that was an error. It was Dr. Cox's gun.
No further questions, Judge.
Redirect.
Dr. Prosecutor asked you questions on cross with regards to where you got the statement concerning sexual abuse allegations made to DCP and P, correct?
Yes.
The trial's
Did you
not getting
review
any
the
louder,
safe
folks. That's as
score,
loud as it gets.
Complaint filed by Lauren Canarak.
I never saw that complaint. I was aware of it through the police investigation, but I never saw the complaint.
prosecutor asked you questions about feigning. What is feigning?
Feigning is faking.
Okay, and did you consider whether or not my client was feigning based on your interviews with him and the review of the discovery?
Well, it's always a consideration in a forensic interview, especially when the stakes are high. And feigning or malingering, which is another form of feigning, can be done for any number of reasons. It can be done in a simple civil context where somebody feigns injuries to get a reward, say an insurance settlement or something like that. Or somebody can feign facts in a case to avoid criminal responsibility. So in evaluating anybody, feigning or malingering is something which is always a consideration.
In your consideration of that, did you find any evidence based on everything that you did to indicate that Michael Barisone was feigning about not remembering the event?
I hate the word any, because any is like any. I don't know, maybe he twitched his left eye and that will be seen by some people as evidence. If you're asking me that I find any significant evidence that he was faking, the answer is no.
Nothing further.
Well, you may step down, Doctor. Thank you.
Thank you, Your Honor.
All right, folks, that's it for the psychiatrists. And I think that's it for me for this trial today. I know there's a psychologist that follows. I'm not going to cover that right now, especially given the pace of the trial. The state's on rebuttal. Things will be wrapping up pretty close. Probably tomorrow I'll cover the closing arguments of the state, the defense, and then the rebuttal by the state before things go to the jury if time allows. But that's my plan at the moment. That would be after around whenever the Edgecombe sentencing is, and I'll be joining Nick over at Ricada Law for the Theodore Edgecombe sentencing by Judge Borkowski. That ought to be a blast. I wish they were doing it at night because if they were doing it at night, which would be ridiculous, of course, but if they were doing it at night, we might have a no tie event. But I suspect they're going to do it sufficiently early in the day that I still have work to do. In which case, you'll just get the tie-wearing version of the bearded attorney, Andrew Branca. Just a reminder, folks, before we go, that we do have a series of law of self-defense webinars, free webinars, our hard to convict webinars. We're running over the course of April and May. These are 100% free, and they show you how to be hard to convict. We bust a bunch of myths of self-defense law, things that if believed, and too many people believe these myths, if they're commonly believed, if followed, are a high-speed path to prison. We don't want that to happen to you. We don't want you to be easy to convict. We want you to be hard to convict. So in these webinars, we bust those myths and we show you how to be the path, the strategy to become hard to convict. Again, the webinars are 100% free. They don't cost a penny, but they are limited. Each is limited to 100 seats, and they fill up fast. We did one yesterday. It was awesome, but it was completely, I say sold out. It was completely full. It's not really sold out because we don't sell the seats, but you understand what I mean. The others are filling up awfully quick as well. As they fill up, the date available will come off that webpage where you can sign up. If you see a date, it still has at least some seats available. You can register for this 100% free hard to convict webinar at lawofselfdefense.com/hard to convict. And I hope a bunch of you will take the opportunity to do that. All right, folks, I'm going to wrap this up now with my little extra video. Remember, as always, if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.